This is the Mobile Home Park Lawyer Podcast with Ferd Neiman. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd Neiman.
Welcome back, Mobile Home Park Nation. Ferd Neiman here again today with another episode of the Mobile Home Park Lawyer Podcast. Got a repeat guest here again. You guys know him. You see him. He's my law partner here at the MHP law firm, Jonathan Gilmore. Jonathan, thanks for coming on, man.
Hey, Ferd, thanks for having me. Excited to be back on.
Yeah, you got it, man. Well, today we're going to cover something that you've got a ton of experience with. We do it all the time with our clients. One of your larger clients, you do it a lot as well. And this is for situations where something goes awry, either timeline or terms for a closing, and we got to get it done. And what do we get done? We use an escrow holdback agreement. So I know you've done a bunch of these. Give us the kind of the 101 on what is an escrow holdback agreement, who's a party to it, how's it work, and we'll go from there.
Yeah, you're right. It's a great topic. I actually see these a lot more. They seem to be a lot more common for whatever reason. Maybe it's just the nature of the deals I'm working on. Probably about 30% of my deals end up at least having this on the table as an option. An escrow holdback agreement is really a tool that we have in our toolbox as far as getting closings. A lot of times, as your listeners may know, and our clients know, getting to closing is key, whether there's a 1031 timeline involved, or there's a rate lock for a loan, and we're trying to hit a certain date. And during the due diligence period, generally that's when we find out there's something that was promised by the seller, oftentimes that was baked into the purchase price. It was really supposed to be part of the closing deal and be done, and it's not. We find out it's not going to be done by closing. So what do? Well, and I'll give you an example here in a second. We decide, hey, in order to get to closing, we're going to keep that closing date. But what we're going to do is we're going to set aside a certain amount of funds at closing. They'll actually be held by a title company or an escrow agent post-closing until a date certain or some milestone or triggering event occurs. So, an escrow holdback, I guess the term is it's the act of collecting additional funds or withholding funds due to the seller at closing that will either be spent post-closing on a certain project or returned or dispersed to one of the parties after the completion of a milestone or the passage of a certain amount of time. And the way we wrap this up is we fill out an escrow execute an escrow holdback agreement. Because as you know, but for certain representations and warranties that survive closing in a purchase and sale agreement, most purchase and sale agreements, they're done after closing. They're either merged into the deed, some clauses survive, but that's not really the document you look to post-closing, especially for kind of a new issue that comes up that needs to be addressed post-closing.
Got it. No, another thing that I want to mention too is, you mentioned there's a 1031 or an interest rate with a hard timeline. Sometimes the timeline is not hard by rule, but it's firm or hard in the seller's mind. So I've had times where the seller was supposed to demolish 20 homes, get titles to 20 homes, and then 60 days goes by, it's time to close, and they're like, and they haven't even started, and then they don't have the wherewithal to do it, skills or money, and at least not time. So I want more time. I want to give them more time to perform. But if I realize they're not going to perform, I may say, you know what, I'll do it, but I need the cash. I need the cash for the demo, and I need the cash and brain damage for the title process. So I can ask for a price reduction, and they may say, no, I don't want a price reduction. I'll say, okay, well then fine. We're going to value this. We're going to value this, say, at $80,000. We're going to put it in escrow. You don't get the money. If you accomplish this within the first 60 days after closing, then you get the money. If you don't, then the title company releases it to me. And sometimes that keeps the seller, they're like, okay, cool. And then they'll agree to do it. And they don't actually do the work in the timeline. And then they often don't. But then I get the reduction, and it's okay to me, because that's one way that I can keep the seller from dropping. Just like, look, I'll give you more time, but they want their money now. Like, I'll give you, it's $1 million deal. I'll give you the 920, but hold back the 80. And another, that's one strategy. Another strategy, I was talking to a guy an hour ago, and he needs more time. And the way he asks for more time is, I will put up non-refundable earnest money. So this is an alternative. So I'll give you a $50,000 firm, for 50 days extra time. Sometimes that makes the seller feel warm and fuzzy because it, quote, pays for the inconvenience. But a lot of times they insist on the escrow holdback, and then I'll let you get back into some other timeline challenges, weather or construction or whatever that just can't be done in certain periods.
Yeah, that's a good story. I've seen that happen. I actually just had a deal with very similar to that story you just had for a client. Yeah, I agree. And with less sophisticated sellers, they may not even think there's an escrow holdback option. And so you as the buyer, if you're a more sophisticated buyer, you kind of come to the rescue a little bit and say, look, I've got the solution. Let's go ahead and close this. Let's go ahead and get this done. And they're relieved because, they needed, like you said, they needed more time. Or maybe you as the buyer might just be concerned that they're not going to be able to perform even if you give them 6 more months. And so this, in some ways holds the feet to the fire. So we talk about this escrow holdback conceptually. The form that we use is called an escrow holdback agreement. And generally from a timing standpoint, before we talk about that agreement, it's a document signed, it's signed by the buyer, the seller, and the title company. And we'll talk about that in a second as well. But, this usually comes up during the inspection period. Sometimes it comes up, let's say 2 weeks before closing, where you've passed feasibility as buyer, you've gone hard on your earnest money. You probably have an out, or at least, you have some out under a contract if it's, drafted, negotiated properly, but you realize they're not going to get to the table. And so you work on an escrow holdback agreement. But in order to do that, you really need an amendment to the contract. You need to come to terms, you come to an agreement with the seller, say, here's what we're going to do. We're going to put this in an escrow holdback agreement. You negotiate the escrow holdback agreement, which we'll talk about. And then you formalize the form of the escrow holdback agreement in an amendment to the purchase and sale agreement. That way there's not any confusion at closing. I've done escrow holdback agreements the day before closing. Seems to be a fire alarm that goes off, and that happens. We try to avoid that because a lot of times we know about it before that. Or sometimes, closing's kicked out 5 days or so just for the sole purpose of negotiating the escrow holdback agreement. But at the end, it's baked into the First Amendment, Second Amendment, Third Amendment, whatever amendment to the purchase and sale agreement. And then it becomes a closing deliverable. So that's
explain the closing deliverable and what you mean by that, because a lot of people are not familiar with that and compared to deeds or other items.
Right. Well, a deed would essentially be a seller closing deliverable. It's basically any document that needs to be either sent to the title company in wet ink form because it needs to be recorded against the property, or it's something else that needs to be signed that doesn't need to be recorded, but needs to be gathered, i.e. gathered seller signature, gathered buyer signature. Like, for instance, an assignment of lot leases or an assignment of park-owned home leases. Well, that would be a closing deliverable item.
And deliverable meaning one party needs to deliver something to the neutral party of the title company, as opposed to, hey, it's in the mail, and or with things like the recorded, there's an order of recordation, for mortgages or second mortgage, and if there's a new easement. So that's also important. And then a lot of times we think of these escrow holdback agreements as something that the seller must perform, but it can go both ways. I had a deal where the original contract said there's 150 space park and there's 20 acres of farm ground. Seller gets to keep the farm ground. Well, the client signed the contract, brings it to me, and I said, it's possible. I'll just subdivide it after closing. I said, it's possible that ruins your grandfather rights, ruins your zoning, so you might not want to do that. So then we didn't want to delay the closing in the timeline. So what we agreed to do in that case was an amendment to the PSA. And I know you say this all the time to our team, is drafting an amendment is a creative, higher level skill than drafting a PSA, because you can put a lot of art into the amendment. And in this instance, the art of the amendment had to say, at closing, we buy the property. We have 120 days to subdivide the farm ground, but in the event it jeopardizes the mobile home park, we get the right to choose not to subdivide the farm ground. And then we either A, sign a 99-year lease with the seller, or B, we have to basically increase our purchase price by X dollars, 100,000. So we put that 100,000 in escrow, because if we were unable to or unwilling to subdivide, we were going to give the seller extra money, because the seller was not going to have the benefit of 20 acres of dirt to sell. So it could go both ways. And it's just the devil's in the details, if you will, which is why it's important to have a well-drafted document and a a strong title company. Tell us about title companies for a second while I mention that, because I know that sometimes is a problem, and people ask us as a law firm, "Hey, will you hold this amount in escrow?" And we're like, "No, we don't do escrow because it's an invitation to be in a lawsuit." And we're biased, right? Because we already have a client issue,
Yeah. So we've talked about the escrow holdback. Now we're kind of talking about the agreement. So the escrow holdback agreement, it's a formal agreement between the buyer, the seller, and the escrow agent or the title company, and it defines the obligations of not just buyer and seller, but also of the title company. And so I always look at it this way. Oftentimes you don't know whether an escrow holdback is a solution, or you need to have it on the table as a solution when you're signing executing a PSA. And so I'm a big proponent of using larger national title companies as the escrow agent on the front end versus Joe and Bob's title company, because what ends up happening, as we just talked about, a lot of these escrow holdback discussions and solutions come up 2 weeks, a week, days before closing. And because the escrow agent needs to be a party to the escrow holdback agreement, you may get to the 2 days, 3 days before closing, and you as the buyer have worked out with the seller how the escrow holdback is going to work. And then you let the title company know, hey, we're going to do an escrow holdback. And I had this happen a few months ago, and they say, we don't do those.
Right.
So now the title company that has taken the earnest money, the title company who has, underwrote the title commitment, and who's going to issue the policy and is conducting the closing. So they're getting all those fees. They're now saying post-closing, we're not going to do the one thing that's going to get this to close. Right. And so you as a buyer or as us as the lawyer on behalf of the buyer, we're now kind of title company shopping and trying to find a title company that will just do one thing, and that's hold money in escrow pursuant to the escrow holdback agreement. And I've had it happen before where the title companies, even if my clients had a relationship with them, they'll say, no, we don't want to do that. Basically, the juice isn't worth the squeeze. We don't want to take the liability that there's a fight and risk that and get in the middle of that between the buyer and seller post closing if we're not going to get the benefit of the premiums for the policy, the closing.
There's not much money in the escrow holdback piece for the title company, but there's lots of risk and liability. So it is definitely a practical problem. And in general, I don't like, I'm not a big firm, small firm, one better than the other, but as far as title companies, if you got a John and Associates and John's the guy handling the closing, that it's not a big shop, and John's not going to want to be in the middle of a $5 million transaction with 100,000 plus of pain and escrow. So it's, little guys are often not built for it. So it is a practical problem that occasionally we run into, especially because generally we're pretty agnostic on which title company. I don't care. People ask me, which title company you recommend? I go, whichever one did it last time on this property because they'd be faster and cheaper, or whichever one has a relationship with you or the other party or is local. There's some benefit to that, but your Chicago titles, your Stewart titles, your First National, Fidelity, those bigger shops, they're used to this kind of stuff. So they tend to. Madison Title, we did one of them recently. Those companies are just a little bit better prepared. Not that a small shop can't be good. I mean, we're a relatively small law firm. I think we're somewhat competent, but all else being equal, size matters.
Yeah, and small shops will do escrow holdbacks as well. They look at that as an additional benefit that they offer to their clients to get repeat business. I think in the instance, the last one where I found out, it was actually a title company my client has used before. It's just those previous deals, there weren't escrow holdbacks. We didn't know about it until we knew about it, right? So timing of not just negotiating the escrow holdback agreement, but also making sure that the title company is looped in as soon as you think there's going to be one, really solely for the purpose to make sure they're okay with it.
So two things on that. We've talked okay with it in general. They'll do it for the money, but then what is the fee? But then what's the form of document? We need to make sure that they are, because you've had it happen where the title company redlines the agreement and you're like, what? But they're like, we're a party to this. We get a chance to comment on it. And that just adds another level of complexity. And that's another reason to do it as soon as you need to and not the day before closing.
Yeah. And that's a great point. you want to loop them in to tell them that it's going to happen, just like you want to tell a title company, hey, we're planning on closing this in 2 weeks versus we're planning on closing this tomorrow, right? Because they're more likely to accommodate 2 weeks. They have the bandwidth to accommodate 2 weeks. Same kind of goes with an escrow, because a lot of times that closing agent you're working with, and even us as the lawyer, we might be solely working with them throughout the whole process, says, what, I have to send this to our counsel. And then they have to take a look at it. And some things that come up from a title companies, what they're looking at obviously is, yes, what are our fees? But that's a lot of times the larger companies, they've got, a standard schedule. And in the bigger picture, they're really not that much.
Right. They're de minimis compared to all the other fees involved in the transaction.
Yeah.
One other thing I just thought of too, another party that's not a party to the signature block of the escrow holdback agreement, but who could be actually, but is a lender. I think about, I've got a deal, Fannie Mae, they may say, hey, we do a property condition assessment. You need to set aside $80,000 for road repairs, and we're not going to trust that you do it. So I just turned one in last, I don't know, Thursday or Friday, where post closing I had to do this work. Well, it's a double whammy, because I have to put the money up in escrow, generally like 140, 150% of the cost. And then I got to go do the work. Now, sometimes let you draw it down like construction draw. In this case, it was a refinance. So it's by refinance proceeds. They're supposed to be $1 million. They say, well, we're gonna hold on to 50. So then I didn't get my 50. Well, then I got to go spend what's probably realistically 40, get lien waivers, get pictures, fill out their paperwork, submit a request. So now I'm in the hole 40, and then I got to wait to get back my 50. And oftentimes you got to do repairs or do work that you didn't think was necessary, but somebody at the lender's shop did for sure. So that's another component of it.
Yeah, that's a great point. Looping the lender in, let them know about it as well, because if the escrow holdback amount gets to be too great, is that a problem as well? What are the improvements need to be done? Is that a problem for the lender? On an underwriting standpoint. So looping them as well. That's a great point. And we often do that when we see, hey, this changes. I mean, anytime as lawyers, we think that there needs to be a substantive amendment to the purchase and sale agreement. We're thinking about, who does this affect outside of buyer and seller? Oftentimes it might affect the lender. We know we have to send it to the title company, not just for closing, but if there's a trade on purchase price, well, that's going to affect the title commitment, the title policy. And so we're trying to keep these, we're kind of quarterbacking a lot of these as the representative of our client, and keeping all these parties, aware of these up until the end is very important, because you never want to have a lender, as say a referee, throw a flag on you the day before closing and time out on the entire deal. But that's a good point, the lender as well. So the title company, when their counsel's looking at these agreements, they're thinking about what happens if there's a fight. I mean, first of all, they want to know, we're not going to be holding these funds in it for perpetuity, right? So closing happens, funds are set aside. They want to see what's being held. How much is it, an interest-bearing account? If so, who's the interest accrued in for buyer, seller? Oftentimes it's seller. What's the trigger milestone for releasing the funds? We can talk about more of that just through the document. And then what happens if there's a dispute? Because a lot of escrow agreements, not only do they want to see, hey, they're indemnified, they're released and indemnified from anything that they didn't do that's wrong, or any dispute between buyer and seller. But what do they do if it goes to litigation? A lot of escrow holdback agreements gives the title company the ability, if there's a dispute, to interplead the funds, give the funds to the district court, circuit court, the local court, and say, hey, it's your guys' problem. Now we're out, and they want to make sure that language is in there. So having a complex escrow holdback, or even a not complex escrow holdback, sometimes requires more than just a downloadable PDF form you found via Google, because you're going to end up getting a flag thrown on you when you think you've got an agreement worked out with, say, the seller, by the title company, who says, you guys need to, you didn't think about us, right? This escrow holdback agreement doesn't consider us, and so and ours do, so that's really key. So
let me kind of jump in on it. I got a comment on, you mentioned indemnification for the title company. That's obviously one of their main concerns, more so than the money even. Reminds me of, whenever you change a document, you add an amendment, you add an escrow holdback agreement, it's always a good time to stop and reflect and say, what ripple effect does this have on other things? Because I was just thinking of the example of a lot of times mom and pa don't have a title to a mobile home. So they'll say, oh, I'll get the title, or they're going to demo these homes. If you hold back money, they don't do it. Great. You now have the money, but do you have the title? Do you have the right? Are you going to get in a future lawsuit? So you got to kind of think, does my bill of sale address indemnification for these units? Does my assignment of leases give me rights to these units? And just think, where else is this here? And we purchase price allocation, 1031 allocation, and cost basis. Does this escrow agreement impact those if it is successfully consummated? And does it, or if it's not successfully consummated? And it's just a good reflection point to stop and be like, if I, it's like if you fix one thing, does it break something else? And
yeah, I call it the butterfly effect in training. You've heard me say it to our associates, which is when you're negotiating a purchase and sale agreement, for instance, if you change the inspection period, sometimes the agreements come to us. Maybe we didn't start out drafting it, or maybe it's a seller's version. It comes to us and it has a hard closing date. And then we change the inspection period. Now does our inspection period run longer than our closing date? It's this ripple effect. I call it butterfly effect, where if you change one thing, does it impact the rest of the agreement? And so, and oftentimes it does, and to your point. So, but when we're drafting the escrow holdback agreement, we talked about the timing. I always think of like an example is you've got a seller who was supposed to complete road improvements. They've got the mobile home park. They're doing $300,000 of asphalt improvements. It's all supposed to be done by closing. In fact, it's in the agreement where the seller says, I'm going to have this done by closing. Well, you as the buyer find out a couple of weeks before, or a month before, or even longer, hey, look, there's weather, some force majeure issue, basically an act of God, right? Oftentimes it's just weather. They're trying to get it done. It's been too rainy. You see that a lot. Or the worst case scenario, you slip into winter early, and then you got to wait 6 months, right? Before or longer, but usually it's about 6 months, depending on where your park is. So they said, hey, I'm going to do this work, and I'm going to have it done by closing. You then start to get to closing, you realize they've only got 2/3 of it done. The contractor's still working to the extent they can. There's been some timeouts called because you haven't been able to get the work done. So you then say, let's solve this problem. Okay, how much left is to be done, right? Let's do an escrow holdback. Okay, you've got 2/3 done on a $300,000 project. There's $100,000. Well, as the buyer, as an attorney for buyer, we say, you need to have the seller prove that up. First and foremost, you need to see, do they have a contract with the paver or the contractor, right? Were there hard bids on it? Is it just more than an estimate? Can you validate, can you substantiate there's $100,000 left? And if there is, and you probably want to hold back $110,000 or $120,000 to have some sort of contingency piece built in there. And oftentimes the sellers will agree to this. So in the escrow holdback agreement, you say, here's the amount of the funds that are set aside. You've already vetted it as the buyer. You know what's going to be set aside at closing. So at closing, $110,000 is going to be set aside for the completion of the road improvements. Those are the seller's proceeds. We put it in the bucket, the escrow holdback bucket. The seller is then charged, in this example, with finishing and completing the road improvements. A couple of things to think about as the buyer or as counsel for the buyer is, okay, what happens if they don't? What happens if the seller walks and says, you know what, your problem, I'll get my money back. I know you have to finish it. So you need to make sure that whatever contract that is, there's an assignability portion. In fact, the seller agrees to assign that contract to you in the event of a step-in right. Basically, a step-in right is where the buyer says, let's say that the escrow holdback agreement says 30 days post-closing is how long the seller has to complete the remaining road improvements. Okay, in the event that the seller can't do that, subject to acts of God or force majeure, and then we negotiate that. In the event the seller can't do that, buyer has the right to step in. They step into the shoes of the seller and then directs and oversees the completion of the road improvements, at which point they're allowed to tap into the funds that were set aside for closing to pay the contractor. So at the end of all of this, buyer finishes the road project, buyer gets the funds, and the job's complete. The seller doesn't get anything unless maybe there's some savings along the way. Maybe they get that at the end, but that's essentially what we're negotiating. And we have to think about that. How do they step in?
Right.
And is that the only thing that they need to worry about?
Well, there are a couple of thoughts on that. I mean, potentially other things to worry about is, let's say there's $100,000 of road work per the seller's contract. What if market changes? What if supply chain changes? So maybe at escrow we hold back 150,000. Maybe we have to get the permission of the concrete guy. Maybe they have to maybe they're a two-party contract. Maybe they don't want to work for us. Maybe that, especially if the market changes or price changes. So we might need to get an amendment to that contract. If they can't perform, what happens if the concrete company goes out of business? We might need a performance bond or some sort of other metric or tool that makes sure this is going to work out the way we want to make it work out. Because I could definitely see it happen, and we have seen it happen, frankly, where we have one the other day, or a couple months back on a kind of a bridge project where the price of the bridge went from 40,000 to 100,000.
Yeah.
Well, the company was supposed to do it for 40 just said no. They said our normal cost was 30. We were going to make 10,000 profit. Now our cost is 70. We're not going to build it for 40. You can fire us. Don't pay us to 40. And then what happens then? So the performance bonds or the additional escrow can help. Ability to step in can help.
And to that point, I've seen a lot of 150% holdbacks, right?
Mm-hmm.
For that reason. If it's something where you've confirmed and the buyer has confirmed that there's hard bids in place or the contract holds up, and it's a little bit of it is a business risk to that extent. But and you mentioned performance bonds that we're using the road example, and sometimes the jurisdiction, the city will require the seller to have posted some sort of financial assurance to complete the project. So if you have to look at that, what's required, what's left to be done? Has it already been posted? Does the seller get that back? If the road's completed, it's not just, is seller okay with the road being complete? Is the city have to come in, do they have to give their stamp of approval? Does the performance period, once completed, draw down or get reduced to, say, a warranty period where it's 10% of the performance bond or financial assurance that was posted with the city or other jurisdiction? And does the buyer really need to worry about that? It's probably the seller's problem, right? Because they're the ones who've posted this. And so they're actually, to your point, that gives them motivation to not walk away from the project, right? Because they've got bonds posted. So, that in some ways that helps the buyer, because we know the buyer's protected because the seller loses more than just the escrow amount, right? They've got other assurances posted. So in order to, I guess to bring it back to the beginning, which is, the buyer, and we assist the buyer with this, needs to know, what's it going to take to get it done? Is it just the seller performing? Is the contractor performing? Are there jurisdictional requirements? Are there bonds, warranty, assurances posted? And is it all on the property? I mean, we're using a great example of road within a mobile home park. Presumably it's all owned by the seller and then the buyer. What if some of that road's not on site? What if it's an offsite improvement? That we come into that on our development projects a lot, where now we have to figure out, it's not just stepping into the shoes. Are those in public right of ways? If we were to happen to take over that project, is there an easement we need or a license agreement? What other items do we need? And these are all kind of complementary and supplemental, additional to the escrow holdback agreement. This is that ripple effect that we talk about, which is, and I like to just get out a map and say, what are we doing? What needs to be done? If it's an improvement, we look at it, we talk about it, we ask all these questions to the buyer or whoever is performing the due diligence on behalf of the buyer, if it's a corporate client, and then we figure it out, and then we paper it up. And a lot of times it is not just an escrow holdback agreement, or the escrow holdback agreement has several other exhibits, such as licenses, things like that accommodate the event of a step-in, for instance.
Yeah, great stuff, man. Lots of confusing and complicating things going to happen. Some stuff we even have unknowns. I remember we had an apartment deal. It was a big number, 20 million or something. And there was a fire in the community center or something. So it was a real cost that needed to fix the fire. We didn't have certainty yet from the insurance company as to what the result was going to be. The buyer didn't want to kill the deal because the community center was almost de minimis value relative to the large complex, but it was still a $80,000 issue. So a price concession is appropriate, and or funds to do it. And the lender may require it. And there's a renovation permitting component to that. So rather than slow the deal, you have to have some levels of flexibility that, buyer gets the the option of insurance proceeds or this much money or this contract. Or so those are more rare in the MHP space. It's rare in general, but you do have those occasional springing or contingent components of an escrow holdback agreement.
That's right. And I'm thinking about that example using a couple others where it's a post-closing agreement. I've had clients before who've entered into these, and then the buyer and seller kind of forget about what needed to happen. It's like someone's, got to be tracking that and following it, especially in the construction world, where, like you'd mentioned earlier, if let's say it's not a $300,000 improvement, let's say it's a $5 million road improvement, and it's miles long. There's a drawdown component, right? And every month or every quarter, let's say every 30 days, the performing party, let's say it's the seller, is submitting invoices now to the escrow company and to the buyer. And they're saying, hey, look, of that 5 million, or in this case, maybe it was 5.5 million, right? Because we're adding the contingency factor in there. They're saying, I've completed this much. This is what I paid. Here are the lien waivers. No one else is going to come back after this money, and it's for 500,000. And so please draw down 500,000. They send it to the title company. Even if the escrow holdback agreement doesn't require buyer's approval, the title company will say, hey, buyer, do you approve of this? And so that comes up a lot too.
That's frustrating.
Yeah. And so and in most instances, the buyers are amenable because they can see progress being made. And so not just making sure the escrow holdback agreement accounts for all these milestones and obligations and who does what, but also making sure that someone's tracking it. In big construction projects, you've got development crews on both sides that are tracking it. But in some instances, I did one where escrow holdback agreement for, I think it was 5 homes where the seller didn't have the title for them. And so there was an escrow holdback done. So it was like, let's say $5,000 a home, which contemplated what the time and cost it was going to take the buyer to go get those titles in the event that the seller couldn't produce them. And they had to do it within 90 days, right? I was tracking it. Everyone else was tracking it. And then, day 89, it's, hey, seller, where are you on this? We'll get back to you, which is the code speak for we forgot, right? And so then the next day you get a counter, right? Can we get another 30 days? Or, hey, we only got one. So you can keep the other,
Well, that's a good point. If it's something that can be divisible, then you could have release price or release tranches, or like, okay, you did one, you get 1/5, or maybe it's you did one, you get 1/10 because you get all 5/5 when you do all 5, something like that. Good stuff. I mean, that's all in the details. Sometimes, construction related stuff. Sometimes I had a bank one time. I got a construction loan. I had to do get a licensed architect to submit it. So that the bank had the architect, which I had to pay the architect, and the bank had the architect say, yes, this was done in accordance with these plans, and now you can release the money. The work was done in a proper manner.
Yeah. That's a great point. I always think of it like the escrow holdback agreement. It really can accommodate just really a plethora of circumstances. It doesn't always work, right? Because a lender might step in and throw a flag. It doesn't work because maybe the number's too big. Maybe the timing isn't just going to work out. Sometimes the seller says, I want my money, and so now what you do, you're looking at other potential solutions and workouts. But the escrow holdback agreement is a great tool for clients to use and for lawyers to use on behalf of their clients. So I'm here to educate your listeners about that if they're not using them already. So,
well, thank you. Well, and to your comment, sometimes the seller says, I want my money, but they say, but I'll take less. I don't feel like doing this, so I'll take 80 cents on the dollar. So it can be another method of retrade post inspection period because it's a closing condition. Like generally you would retrade price before your inspection period goes firm. But this could be, hey, this came up, last minute, the building was on fire. We're not going to close. Our lender won't let us close because it's not safe or it's not permittable unless we have a plan and a process. So we need to delay closing. They don't want that. We need you to do the work. We don't want that. Or we need the money, and then we will sign a different agreement with the lender, and the lender will probably hold some of our loan proceeds, and that becomes a form of escrow holdback agreement, if you will, in the form of a lender escrow.
Yeah, that's a great point. Touching on the part that you mentioned where something doesn't happen, or something that should have happened doesn't happen, and the seller at this point says, you know what, I'm not going to do that. And that's when, if the buyer wants the deal bad enough, and this happens a lot, where they say, you know what, I'll do it. So then that's when the work starts, right? Which is how much, if you're in a new market, or it's not a market you've been in before, like, who are the subs? Who's the party who's going to perform? Do you have time to get bids? Are they hard bids, right? Because we talked about before, hey, this is what it costs now. This isn't what it costs a month from now. Well, you can get rate locks on, some of my larger clients, they get these prices locked in because they negotiate them, on a larger wholesale kind of component. But for, buyers this might be their first time in an area, you really have to, now it's back in your court to do extra due diligence to make sure I'm not going to agree to a $50,000 holdback and then lose 30 grand because it took $80,000 to complete the task, even though I got a $50,000 price reduction. That's where you really have to make sure that price reduction aligns with the deal, which is why escrow holdback works out better sometimes, because you'll agree to a larger amount to be held back. You get some wiggle room in there. Also, the seller might actually be in a better spot to be negotiating these deals, especially if they already have a contract under. I had an escrow holdback where the seller was an RV park seller, was supposed to demo 10 RVs, and they got a contract and they got a bulk deal, and so if that's a good price, the buyer has to look at, well, if this doesn't get performed, it's probably in my best interest to keep going with that contractor, right, to demo it, because I probably get close to that same price. But it really does put the onus on the buyer to make sure that they vet out that price reduction, you complete the work. So, and we have a lot of clients that end up agreeing to that as well.
Great stuff. I feel like we've hit this thing. Anything you can think of, anything from your notes or your history that you can think of that we missed, or you want to cover? Any other tips?
No, I think we talked about everything. I think this was good. So.
All right. Sounds good. Well, thanks. Until next time.
All right.
Safe. God bless.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.